Welcome, everybody, to the Citizens Law School. My name is Brenda Waller, and I'm a member of the Law Related Education Committee of the State Bar. Tonight, we are going to learn about small business and employment law with our presenter, Amy Christensen from Christensen and Prezeau Law Firm. Amy is a managing partner who has over 26 years of experience litigating cases in state and federal court that involve employment matters, healthcare, and professional liability. She has also appeared on behalf of clients before numerous administrative agencies involving matters such as discrimination and retaliation, unemployment insurance, wage and hour, and professional licensing. In addition to her litigation practice, Amy advises a wide variety of large and small employers on legal matters related to performance management, termination, disability accommodation, workplace investigations, personnel policies, employment contracts, overtime compensation, and compliance with state and federal employment laws. Prior to forming Christensen and Prezeau, Amy was managing partner at Hughes, Kellner, Sullivan, and Alke, where she had worked for 16 years. So without further ado, I'll turn the program over to Amy. Welcome.
Thanks, Brenda. And thanks to the State Bar for doing this. This is a great opportunity to get some high-level information about employment law in particular, which is my area of practice. So I appreciate you having me. I'm going to share my screen. And we just tried this out and it worked. So fingers crossed. There we go. Okay. So I'm going to talk to you today about employment law primarily and kind of the topics that we're going to talk about, which let me jump out of this for just a sec. There we go. Okay. Thank you. Bearing with me. Okay, so the things that we're going to talk about today are the Wrongful Discharge from Employment Act. We're going to talk through generally what it is and why it's important, and then also how to manage employees' performance so that you're in compliance with it. And my background is really advising primarily employers, and so I will give a lot of information from that perspective. So the Wrongful Discharge from Employment Act was first came into being in 1987, and we're the only state in the country that has a statute like this. Most other states have generally a lot of the same rules, but they come out of cases. So most states, the general rule is employment is at will unless, and then there's a lot of exceptions that can be kind of tricky for employers to navigate. In Montana, we have all of those rules put into the Wrongful Discharge from Employment Act. And so it does provide some level of certainty. And I often hear from clients that Montana is such an employee-friendly state, and how are employers supposed to do business here? And there's some frustration from time to time about that. And I guess in my experience and in working with this particular statute, I have not found that to be the case. I feel like that the WDEA has really struck the right balance between a little something for employees, a little something for employers. So, you know, we do have a little bit of at-will employment, but also some requirements about what the employer has to show before terminating somebody. There's also limitations on damages. You can get up to 4 years worth of lost wages and damages if you're wrongfully discharged, but you can't get attorney's fees or emotional distress damages. So there's this balance that was struck through this compromise between employer and employee groups back in 1987. So what is it and what does it do? And let's first talk about what is a wrongful discharge. So the general rules are found in these 4 subsections about what is a wrongful discharge. A termination is going to be wrongful if it's retaliatory, and there's a specific kind of retaliation that is at issue. It's a retaliation if the employee refuses to violate public policy, like you say, "Hey, employee, I need you to go and fudge our books just a little bit to make it look like we're making less money so we don't get taxed as much." Well, that's a violation of public policy. If the employee refuses and then the employer fires that person, they would have a cause of action under this statute. It's also wrongful for an employer to fire someone for reporting a violation of public policy. So in the example I just gave, if that same employee went and said to the Department of Revenue, hey, this company is not being honest on what they're reporting as their income, and then the employee gets fired for doing that, again, wrongful discharge. So that's the retaliatory wrongful discharge. There are more damages. You can recover punitive damages for a retaliatory discharge. Another way that an employer can wrongfully discharge somebody is if they fire that person outside the probationary period and they didn't have good cause. And I've highlighted those two terms there because they are terms of art and they have specific meaning, and I want to talk a little bit more about them. The third way an employer can wrongfully discharge somebody is if they violated an express provision of their own written personnel policy before the discharge, and that violation deprived the employee of a fair and reasonable opportunity to keep their job. So this is one of the more recent changes to the statute. It's always been a wrongful discharge to violate a personnel policy during the discharge, but the legislature in 2021 provided a little bit more clarity to what kinds of policies have to be at issue and when that violation has to occur. So we know it has to be before the discharge. Before this change, we would sometimes hear from employees who would say, I've been wrongfully discharged because you violated a personnel policy when you didn't give me the grievance policy within 3 days, and that's what your policy says. Well, that maybe that's true, but it didn't cause your discharge. It didn't it didn't happen before you were discharged, and it didn't deprive you of an opportunity to keep your job because you'd already been discharged by then. An example of a policy that, if violated, might create a wrongful discharge would be something like, before you discharge somebody, the president has to sign off on it. And so if a mid-level person fires an employee without getting the president's sign off, then, and that happened before the discharge, obviously, and had the president had the opportunity to review the discharge, it's possible that the president would have come to a different conclusion. So that is a situation which deprived the employee of a fair and reasonable opportunity to keep their job. There's probably some other facts that could impact that one way or the other, but that's just a generic example of the type of policy violation that could be wrongful. And then lastly is this subsection D. And this subsection was added just in this last legislative session. So it is new and it's newly effective. And it says that a discharge is wrongful if the employer terminated the employee solely based on the employee's legal expression of free speech, including to things that they post on social media. So that legal expression of free speech, we'll talk about that, what it means, what it may not mean. There's some questions about that, but that is new. So it's important for employers to be aware of that one. Okay, so starting with the probationary period. The probationary period under the Wrongful Discharge from Employment Act is the only time in the employment relationship where the employment is at will. And that means you can terminate without good cause. It doesn't mean you can terminate for any reason, because you can't terminate for a non-discriminatory or a retaliatory reason. And so you can't, if you terminate somebody because they complained about sexual harassment, well, the probationary period won't protect you because that's a cause of action that would arise under a different statute, like Montana Human Rights Act. The probationary period only protects against wrongful discharge claims. And so it's only a situation where you would have a defense to a claim that you lacked good cause, because in the probationary period, you don't have to have good cause. The probationary period default is 12 months. That's also something that was changed relatively recently in the 2021 legislature. It used to be 6 months if an employer did not establish its own probationary period. You can establish any probationary period you want, although I think that the I don't know, general conventional wisdom is that 12 months is probably the outside of what I would establish as an initial probationary period. Because if you make it too long, you're kind of undermining the rest of the statute that requires good cause to terminate. You can't just have an indefinite probationary period, but you could set it for 6 months if you want, 9 months, 11 months. But if you don't set it at all, it's going to be 12 months. And I think 12 months is probably that sweet spot. 6 months is a little bit too short. I have sometimes seen probationary periods of 90 days, and that's definitely too short. I mean, I would have clients calling and being like, well, we're at day 89, and I just don't know. I just don't know if this is going to work out or not. Can I extend the probationary period? And at that time, before 2021, we didn't know the answer to that question. And so it was like, well, the answer is you should have had a longer probationary period. So 12 months is a nice time period because typically an employee will be able to go through all of the employer's cyclical work and have a chance to demonstrate what they can do throughout the year. So it's generally a pretty good period of time, sufficient to assess whether the employee is going to work out or not. In the 2021 legislature, they decided that the probationary could be extended up to 18 months. I haven't seen a situation where I've had an employer do that yet, just because I think 12 months is usually sufficient to assess whether it's a good fit. So I don't know how much that's going to be used, but it is available. I would definitely not wait until after the 12 months to extend it. I wouldn't be like, okay, it's been 12 and a half months. I think we're going to go with the 18. I think that's too late. If you cross the threshold of whatever the original probationary period was that you either decided or the default one, now you're in good cause land. You have to have good cause to terminate. You don't get to restart that probationary period. So like I said, the probationary period really is this time to assess whether the employee is a good fit. And so one of the other changes that the legislature made in 2021 was to allow the employer to exclude from that time period any absences, consecutive absences of 5 working days or more, not including holiday or vacation. So if somebody goes on vacation for 2 weeks, you don't get to exclude that from the probationary period. The probationary period just keeps running. But if they have a sick parent and they need to take a month off, or they have their own illness or accident and they need to take a period of time off, consecutive time, you can exclude that. You can stop the probationary period when the absence begins, and you can restart it when they return, so that you get the full benefit of the entire probationary period, and it's not curtailed by that employee's absence. So that's kind of a nice addition for employers. Okay, so outside the probationary period, an employer has to have good cause to terminate the employee. So what is good cause? Well, there's a specific definition in the Wrongful Discharge from Employment Act, and it says good cause is reasonable job-related grounds for dismissal based on any one of these 4 things. So one is failure to satisfactorily perform job duties. That is just the typical, you're not doing a very good job in your performance. And so what you're doing is not satisfactory to us. Another one is disruption of the employer's operations. That could be any number of things. Sometimes it's just absenteeism. Like if you operate a store and this employee is the person who is supposed to open the store and they don't come and they call off after their shift starts, well, now they've disrupted the employer's operations. And so that can be an example of when you would have good cause to terminate. Material or repeated violation of an express provision of an employer's written policies. So this could also be an attendance issue. It could be other things too. But if you have an express written policy that says thou shalt not do something, and the employee, and it's really an important policy, thou shalt not steal, or you can't punch your time card for somebody else. Those sorts of things, those are pretty critical things. If somebody violates them, you might have good cause. Alternatively, it's a repeated violation of a policy that can create that good cause to terminate. And then lastly, good cause is other legitimate reasons determined by the employer while exercising its reasonable business judgment. The Wrongful Discharge Act has always had the other legitimate reasons kind of catch-all term in it. And the legislature again changed this to add that those reasons are determined by the employer while exercising its reasonable business judgment. I think that gives the employer more latitude to make decisions about whether to retain the employee. So that was an addition in 2021. The kinds of things that fall under that catch-all phrase are typically economic. So a lot of times it's a reduction in force. Those would be legitimate reasons to terminate someone such that it rises to the level of good cause. But it can be other things as well. Okay, so I mentioned this term legal expression of free speech. It is a wrongful discharge to terminate someone who has engaged in illegal expression of free speech, including posting on social media, which is part of the statute now. I think that this is aimed at people who post potentially political things. I think I have not come across this in my own practice where there was a problem of an employer being unhappy with an employee who posted something political and the employer disagreed with what they were saying. I think this is something that has been discussed in other states. I haven't seen it here. Other attorneys may have seen that. I'm not sure, but I think that is the source of this change to the statute. So the question now is, what sorts of postings will be such that you could terminate somebody, and which are going to fall into this category of legal expression of free speech? We don't know that yet. And I think there's a range of possibilities for how this could go. So you might have a situation where an employee posts something that is threatening to another employee. It could be physically threatening. It could be another kind of a threat. But if it's physically threatening, that is likely not going to be free speech. And so you could fire somebody for that, hypothetically. But what if it's something short of that? I mean, I think a threat of physical violence is going to be criminal in nature, and it's going to be at one end of the spectrum of not legal expression of free speech. So what if you have an employee who posts something about a supervisor, like, that supervisor drinks at work all the time. I saw it and they're not qualified for their job. Well, if that's true, it's not defamatory, right? But if it's not true, it will definitely hurt that person in their occupation. It could be defamatory. Is that a legal expression of free speech? It could be unlawful in a civil situation, like you could get sued for defamation and have to pay damages, but you can still say it. It's still a legal expression of free speech in that you're not going to be jailed for doing that. And law enforcement can't prevent you from saying those things. So I don't know if unlawful means only criminal, or I'm sorry, legal expression of free speech only applies to the criminal setting, or if it's going to get into the civil side too. Another situation might be if you had an employee who was kind of bullying a coworker on social media. So it could be something like, I don't like you. I don't like how you dress. I think you're a slob, and don't ever talk to me at work again. That's a legal expression of free speech. But is it going to create problems in the workplace? Yeah, it's definitely going to create problems. And the employer might be thinking to itself, I don't want that person working for me anymore because they're really creating some problems within the workplace. But if you fire them, are you going to get sued for wrongful discharge because it was a legal expression of free speech? I don't know. I don't know the answer to that. I think it might take some time for these cases to develop, and until we get some guidance from the courts about the parameters of this particular element of wrongful discharge. So that's one to keep an eye on. But if you are running into a situation where you're thinking about taking serious action against somebody because of something that they posted on social media, definitely want to get counsel to help walk you through that to see, what are my risks here? So keep an eye on that one. Okay, next is the grievance procedure. So a grievance procedure is, it's a way for an employee to bring a complaint forward to the employer, and it provides a process for the employer to consider and respond to that complaint. So a lot of employers have them, but not all of them do. So the thing about the grievance procedure is, under the Wrongful Discharge Act, if an employer has a grievance procedure and provides that procedure to a departing employee within 14 days, then they will have a defense to a wrongful discharge claim. And that defense is really, really powerful. It can wipe out the claim before it even gets started. So there is some real benefit to having a grievance procedure. The statute used to say if the procedure is provided within 7 days, it now provides for 14 days. I don't know that that is super helpful to employers, because usually you don't want to wait 14 days in order for the process to get started. You kind of want to get it kicked off. And so I recommend that employers provide the grievance procedure with the termination letter, or with the acceptance of resignation, or whatever it is, whatever document you're giving to them as they're walking out the door, so that they have it. And then the time frame on your grievance procedure will start to run then. So, I mean, a lot of people will say, you have 10 working days to grieve whatever it is you're upset about. Well, if you wait 14 days to give it to somebody, it's like, well, okay, now how much time do I have? Does the time run from when I was terminated? Does it run from when I got this? Well, I just got this, and now I only have 1 day. How does that work? Well, that's why I'm saying I think it's just easier, cleaner. You avoid all those questions if you give the grievance procedure to the employee at the time that they're leaving. So the grievance procedure itself, there's no specific requirements in the Wrongful Discharge Act in terms of what the grievance procedure has to include. And employers can decide for themselves what is going to work best for them in terms of the structure of the grievance process. So I've seen employers have multi-step grievance procedures. So the first step is to the supervisor, and then the second step is to the president, and then the third step is to the board, and there's a full hearing at the board. That may work for you. I think it tends to be overkill. In what I hear from my clients is, it's too much. We're just going through this process over and over and over again. So that is kind of anecdotally what I hear. So I think you can do this in 1 step. You can do it in 3 steps. You can do it in 5 steps, however many steps you think works best for you. And you can also decide what is going to be grievable. So we're talking about terminations here because like I said, it sets up this defense to a wrongful discharge claim. But your grievance procedure can be as narrow as a termination. It can be as broad as anything you're unhappy about, you can file a grievance. It could be something somewhere in between, like you can grieve any discipline. or you can grieve any discipline higher than a written warning. I mean, you can decide what makes the most sense. I think one of the benefits of having a broader grievance procedure is that employees will raise issues with you before they go to litigation or before things get really out of hand and they're very upset. It provides a way for resolution of things at that level. The downside is you might have an employee who likes to complain, and then you get multiple grievances because your procedure is so wide open. And so they can grieve anything. They can grieve their supervisor didn't greet them in the morning. And so they're feeling like that relationship is going south and they're unhappy about it. And they want to run that through the process. You may not want all of that. So it's trying to find what is the right balance for you as the employer in terms of making sure people are bringing issues to you, but not bringing every single issue to you for resolution because you have other jobs to do too. So that's an internal discussion to have to figure out what is the best grievance process for us. So I mentioned that one of the major benefits of having a grievance procedure is this defense that it creates to a wrongful discharge claim if you give it to the employee in a timely way and the employee does not use it. That's a really strong defense. Another benefit is that it gives the employer an opportunity to review the decision that they made, take a second look at it. Here, you might hear something that you didn't know before from the employee. And so it's just a healthy exercise in double checking what you've decided to do. It also gives you a little bit of insight into what the employee is thinking. So especially in a termination, like if they are going to pursue a wrongful discharge claim, they're going to file a grievance, and you can kind of get a sense of what are their arguments? Do we have risk? What should we do? So it's information to help the employer kind of gauge what they want to do next. So as you can tell, I like grievance procedures. I think that they are beneficial when they are crafted in a way that makes the most sense for the employer. So a couple of tips as it relates to grievance procedures. Mainly, I recommend providing the grievance procedure to every non-probationary employee who leaves. And that's because sometimes you have an employee who leaves who you think has left on really good terms. Like you've thrown a party, they have friends, they still socialize, it's just been a really good situation. And it feels like they're moving on to something that's really positive for them, and everybody is happy for them. Well, and that is all good. But every once in a while, that person will file a claim and say, I didn't want to go. I was happy there. I felt like I got pushed out by my new supervisor who didn't seem to like me and like my coworker better, and I didn't get the promotion I wanted. And so I just felt like I was at a dead end and I needed to go somewhere else. And I feel like I've been wronged. Well, if you haven't given the employee the grievance procedure, they can just go straight to the courthouse and file that claim against you. And you probably don't want that. And you don't want to lose this defense that you have. So it's best to provide the grievance procedure to every employee who leaves, just as a matter of course. The Haynes versus Shodair case is a good example of that one. In that case, Mr. Haynes was an employee who left employment. He was not fired. He claimed that he was constructively discharged. And a constructive discharge under the Wrongful Discharge Act has the same legal effect as a wrongful discharge. It's a resignation, but it's under working conditions that were so intolerable that a reasonable employee would have no choice but to leave. So if the employee can establish those intolerable working conditions, and that they resigned because of them, they can still have a wrongful discharge claim. So you just never know if you're missing something. And so giving every employee who leaves a grievance procedure and requiring them to go through that process before they can bring a claim against you is just a good practice. And in Haynes, he had been given the grievance procedure. He did not file a grievance, and he went to filed his wrongful discharge claim in court, and he argued, well, I left. They didn't terminate my employment. I resigned, even though it was a constructive discharge. And the court said, yeah, well, constructive discharge equals wrongful discharge. You're still subject to the same requirements of the statute. You have to file a grievance procedure if you received one in a timely manner. So he lost that case because, again, he didn't file the grievance. Hathaway versus Zood Enterprises is a more recent case. And in that one, Mr. Hathaway was fired by a supervisor. He was given a copy of the grievance procedure, and he didn't file a grievance. And he went and filed his complaint for wrongful discharge. And the employer said, whoa, we have this great defense. You got the grievance procedure. You didn't file a grievance. We win. And he said, well, not so fast. I would have had to have filed the grievance with the supervisor who fired me. So how much sense does that make? That would just be futile. I shouldn't have to go through that process. It would be meaningless. And the court said, that's not what the statute says. You cannot prejudge how this would turn out. And even if you're grieving to the same person who made the termination decision, you still have to do it because that's what the statute says, and that's what your procedure says. And so because he had not filed a grievance, he lost. Case was dismissed. So again, another example of how powerful that grievance procedure can be. Okay, get a drink. So that is essentially the Wrongful Discharge Act. Now I want to shift gears just a little bit to talk about performance management and how to deal with issues that are arising with employees in a way that is compliant with the Wrongful Discharge Act and helps put you as an employer in a position to defend yourself if you get sued. Okay, so performance management really has two goals to it, at least in terms of how I think about it. The first is that it gives the employee notice and an opportunity to get better. You're telling that employee, here is what you're doing wrong, and I need you to fix that and improve. And if they do that, that's great. Because you're going to get an employee who's doing their job, and the employee's going to get to keep their job. So it's really a win-win. You don't have to deal with the turnover of terminating the employee. They get to stay on. It works out well for everybody. So I think that's a really helpful aspect of performance management. The other is that it helps you achieve compliance, like I just mentioned. If the employee does not improve their performance, then you are in a position to have developed that good cause as required by the Wrongful Discharge Act. And it's virtually the same under the discrimination laws. It's not called good cause. It's called a legitimate non-discriminatory reason for termination. But as a practical matter, it's essentially the same thing. You've given the employee, you've told the employee what's wrong. You've given them a chance to do better. You've warned them of the consequence. They haven't done better. You have developed the evidence that you need to defend a claim if one is asserted against you. So what tools do you have to manage performance? Well, one of them, like we talked about, is the probationary period. And it can be an employer's most useful tool in a lot of ways. It works especially well if the employee is just not a good fit. Like, they tend to be late 5 to 10 minutes every single day. And they just are not getting along with the person who sits across from them. And they tend to talk too loud and laugh too loud, and they just grate on everyone's nerves, and their performance isn't awesome. There's nothing like in and of itself that you would terminate them for, but you can just tell they're not working well as a member of the team, and you just need to part ways. The probationary period is a great tool for that, but it also has its limitations. And so you need to really keep an eye on potential risk factors like membership in a protected class. So If you've got a pregnant employee, I would be really cautious about using the probationary period, because that probationary period will not protect the employer against a claim for discrimination. The other types of risk factors to look for are recent complaints about the workplace, complaints about wage and hour violations, safety violations, hostile work environment, any of those kinds of things. They provide an extra layer of protection for the employee. It isn't that you can't ever fire them, but you just have to be pretty cautious, and you can't use the probationary period. If you use the probationary period, you're essentially, most of the time, acknowledging that you don't have good cause. Well, if you get sued for discrimination and you've just acknowledged that you didn't have good cause to fire somebody, it can create real problems for you. So it's just a good idea to make sure that you don't use the probationary period as a catch-all, get out of jail free sort of card. It really is important to look at, do we have these other risk factors? And because it's important to pay attention to that before you make a decision. The other really good tool is a performance evaluation. I think often underutilized as a performance management tool. They're very useful in situations where you have an employee who has a lot of problems, attention to detail, getting along with people. There's just a lot of this stuff that's swirling around, and you haven't dealt with it in a formal way, but there's a significant amount of it. If you haven't done a performance evaluation, that is a really good way to pull all of that together and to provide that feedback, because you're not responding to a single, like a one-off sort of, you screamed at your coworker, you punched the customer, whatever. Those are one-off. We can act on that alone. This is like a lot of times smaller things. So performance evaluation, it's really good practice to do a formal one at least once a year. I mean, probably at most once a year, but providing that feedback to the employees so they know how they're doing. And then you can also do informal ones. It's not that you can't, but you can do informal ones just on an as necessary basis and provide that feedback. Really important that feedback be constructive in nature and not sugar-coated. So the reason for that is because a sugar-coated performance evaluation doesn't help anybody. It doesn't help the employee do better because they don't really know that there's problems. And it doesn't help the employer, because if there are performance deficiencies, then you haven't done anything to address them, which means you haven't moved the needle at all for the employer if those same problems persist. So if in 1999, you're giving this performance evaluation where you mark every category satisfactory, meets expectations. Well, maybe they're just not great. And your supervisor is just kind of conflict averse, and they don't like the tension of having to tell somebody they're not doing great. And so they just are like, okay, I'm just going to make everything satisfactory. Well, the next supervisor who comes in sees these same performance issues and is like, I got to do something. I'm ready to fire this person. Well, their last performance evaluation was all satisfactory. So it doesn't help the problem going forward. It just kicks the can down the road, and you're just not getting to a place where things are getting better for anybody. So the performance evaluation feedback really needs to be constructive and honest. And either the employee does better, which again, win-win, or you have created some documentation of the performance issues that you can use if they persist. Okay, so the other tools you have for performance management, disciplinary action. And that disciplinary action, it can be progressive in nature, where you just kind of march lockstep through the different levels of severity, but it does not have to be progressive. So for example, if you got somebody who does something serious, like steals from you, you don't want to be giving them a verbal warning. And if your policy is a strict progressive discipline policy, that may be where you're stuck, because if you do something more serious, you get sued for violating an express provision of your written policies, and we don't want that. So progressive discipline has its place, but a strict progressive discipline policy can really trip you up. So you want to just have the flexibility to choose the right tool. So progressive discipline, that kind of marching lockstep through the different levels of severity, that works really well if you've got somebody who is an underperformer, or and that typically that underperformance is chronic in nature. It just is not getting better. It's, a lot of times that happens with people who deal with numbers, and their numbers are not accurate, or, a payroll person who just, the payroll is just not accurate. It's close, but it just, every single pay period, there's something wrong, and employees are getting upset, and it just is not getting better. Then it's progressive discipline works well, because you can start with a conversation like, hey, just want to make sure we're on track, double check. And then still doesn't get better. Then you can start talking about a written warning, and then you can start upping the ante as you go along if that performance doesn't improve. Absenteeism and tardiness issues also, they're kind of chronic in nature sometimes. And so progressive discipline works really well for addressing those kinds of things. So here is just a list of possible options for disciplinary action. And again, it's really important to pick the right tool for the performance that you're trying to address. So low level, obviously, you're going to be looking at a corrective counseling or verbal warning. More serious, you're looking at termination. That bullet in the middle for disciplinary probation / action plan / PIP, that is one of the disciplinary tools that I really like to use, because it's sort of a last chance deal. And I put 3 different names in there because it's the same tool, but people call it differently. And so one of these names, disciplinary probation, might not be familiar to some employers, but an action plan or a PIP, a performance improvement plan, it might be. And so it's same tool, different names, but the effect of it is that you kind of say, okay, look, we have been talking about this for 6 months. We have done a verbal warning. We've done 2 written warnings. Things are still not getting better. We got to get this figured out if you're going to continue to work here. So for the next period of time, I think 90 days is often a good time. For the next 90 days, you are going to have these expectations in place. And we're going to meet every other week. And we're going to talk about how things are going. I'm going to give you some feedback. We're just going to see how it goes. And as we go through this, we're going to be watching to make sure your performance is on track. At the end of it, if your performance is not on track, we're not going to continue your employment. If you have some improvement, but that isn't sustained, we're not going to continue your employment. If you have new performance issues that develop during this time, we're not going to continue your employment. And we don't have to wait the whole 90 days, because if it's clear to us that in 30 that you have not shown any interest in getting better, we're going to let you go. So it just kind of sets this, it's like the culmination of your discipline, short of termination, but it's the culmination where you're saying, this is it. This is your last chance. You have got to do better. You're either going to rise to the occasion or you're not. And if you rise to the occasion, great. We're happy. If you don't, then we're going to part ways. So it's just a really good tool to use where you've worked on this stuff, worked. It's not getting better. You just want to make it really clear. Your job is on the line. You have to do better to keep working here. So a really good tool to help manage performance. Like I said, you want to choose the correct tool depending on what the circumstances are. You don't want to underreact and be like, I don't really like managing people, and so I'm just going to kind of let you off lightly. But you don't want to overreact either, and do something far more serious because you're mad. You don't want to do something too serious in that circumstance. Typically, you want to get a response from the employee and hear what they have to say about what you're trying to address. I think a suspension to give yourself some time is really a good idea in a lot of situations, because sometimes when you get an employee with a performance issue, it just is super frustrating for the employer, and that there's emotion that comes with that, and that can be really upsetting. And so a suspension where you send them home, you can call it administrative leave, you can call it whatever you want, but you remove them from the workplace with or without pay, depending on the circumstances. But that just gives you some breathing room. It's just a placeholder so you can be thoughtful about whatever decision you want to make next, because you don't want to make that decision when emotions are really high, because it's really hard to take back. You definitely want to review your policies before taking any kind of disciplinary action. Make sure you're in good shape. Sometimes you'll have a policy that addresses the conduct. Sometimes you won't. And then you want to look at the employee's performance history, especially if you're a newer supervisor or you're unfamiliar with this particular employee. You want to see what ground has been plowed here. Is this the first time anybody's had an issue with this person, or is it the 12th? So that's always good to know. Okay, so let's talk for just a minute about disciplinary documentation, because this is a question that I think a lot of employers have. Like, how do I do it? Like, what do I put in there and what should it say? Well, the content is important. It's important to talk about 3 things: what the employee did wrong, what you expect from them going forward, and the consequences if they fail to meet those expectations. So the letters will look very different depending on the facts and circumstances, but those 3 things need to be in every letter. When you talk about the performance deficiencies, be objective. Don't say, well, the employee, you just continue to have a bad attitude. Well, you should just you could get that same point across with more objective language. Like, when we had the team meeting, you pushed back from the table and sat with your arms crossed and your head down, and you did not participate in the discussion. So that caused concern about your contribution to the team. That is way better than saying you have a bad attitude. And then also consider your audience. So the letters that you write for discipline might be viewed by a fact finder, like a judge or a jury or a hearing officer somewhere down the line. And so you want to make sure that whoever is reading that letter reads it and thinks, oh yeah, I get it. I understand why they did what they did, and that makes sense. So keep that in mind as well. Your expectations should be clearly worded. The employee needs to know what they can and can't do. And then you want to make sure that the consequences are also set out there. You want to say, it could be something like, giving you this written warning now. If you don't meet these expectations, further disciplinary action will be applied up to and including termination from employment. The process that you follow is also important. Again, you want to review the policy in advance, because a violation of a personnel policy can create a wrongful discharge, even if you have good cause. You want to provide a copy of the discipline to the employee and have them sign that they got it. A lot of employees will be like, I'm not signing that thing because I don't think this is right. And that's okay if that's what I will usually recommend not saying you have to agree to it. It's just signing that you've received it. And the employee might still refuse. It's not a hill to die on. I would just make a note on the documentation, employee refused to sign, and date it. Not a big deal. So termination. Biggest rule, don't fire in haste, because that is a decision that's really, it's hard to unring that bell. Or as someone said the other day, can't put the toothpaste back in the tube. That's what happens. You're going to be in that situation if you fire somebody in haste. You just can't undo that. You definitely want to hear the employee side of the story, because that is helpful information to know before the decision is made. You don't want to hear that their side of the story after they've sued you and you didn't know it ahead of time. That's bad time. Review your policies, make sure that you've got all approvals, everything's in order. Discuss the termination with HR. If you have an HR department, they typically have a broad knowledge base of what other sorts of situations have been terminable. So if you're trying to figure, or you're trying to terminate this pregnant woman, you might have the HR person will say, well, we did have that white guy, the white 20-year-old do that same thing 6 months ago. We didn't fire him. Well, that's good information to know, because you don't want to set up a situation where you trigger a discrimination claim. It's a good idea to have the termination letter reviewed again, because somebody else might be looking at it and you want to make sure the tone is correct, it's objective, all of those things. And then make sure you're providing a copy of the grievance procedure. I did want to mention termination letters, because there's this very recent case that the Montana Supreme Court decided just within the last few months. In the Smith versus Charter Communications case, Mr. Smith was fired for a couple of reasons, one of which was he had not traveled to his territories 50% of the time, which was one of the requirements of his job. So the termination letter said that, and this other reason that isn't important for this discussion. And so he sued, filed a claim for wrongful discharge, and they briefed it on summary judgment. And during the briefing process, some other information came to light. And so when the court was looking at this, it made a decision saying, well, I don't know for sure that you were fired based on the 50% travel requirement, but it's really clear that you at least didn't meet the quarterly travel requirement. So summary judgment for charter, they win. Well, Mr. Smith says, well, wait a minute. The quarterly travel requirement, that wasn't in my termination letter. So they can't start making stuff up after the fact. They are stuck with what is in the termination letter. And they relied on this older case from like 1996 called Galbraith. Charter said, no, there's this other statute that says we can add to the termination letter if we want. Well, this case was in the federal system, and the Ninth Circuit took a look at it and they said, I don't know what the answer is, which law you apply. Courts are doing it differently. So they sent this to the Montana Supreme Court and said, Montana court, can you tell us what it is what's the rule about termination letters? Do you have to include every detail that led to the termination decision, or can an employer add things after the fact once they get sued? And the court said, what you do need to explain the termination decision, that you need in your letter to provide the basis for why you decided to let this person go. But if there's a lawsuit later on, then the employer can offer evidence to substantiate the reasons given in the discharge letter. So I guess the way that I think about this is, if the employer is sued after firing an employee for attendance issues, and the letter says, we're firing you for attendance issues. We told you on these 3 dates that your attendance had to improve, and it didn't. And you continue to be gone. And so we are letting you go. Well, when they get to court to defend the wrongful discharge claim, they can explain, well, here are the specific dates. Here's the information that we had about these absences. And they can talk more specifically about the absences, because those are reasons that are being offered to substantiate the discharge decision. Discharge decision is attendance issues. Here are the more specific attendance issues. That seems to be fair game. What you can't do is offer irrelevant reasons that are collateral to the discharge decision. So for example, if it's attendance, that's the reason you let somebody go, and the letter says it's attendance, you can't then get to court and say, well, yeah, and also this person could not get along with anyone, really, really difficult. And so we definitely factored that in, and here are all the times we talked to her about that. And so, yeah, that contributed to the decision. The court won't allow that. So the takeaway for me from that charter case is, you really do need to be thoughtful when you're writing that termination letter and be aware that if there is something that factored into the decision to terminate, you need to put it in the letter, because you may not be able to do that later. At least kind of the overall topic, like can't get along with people. If that's why you're firing them, that's fine. You can always give the examples of them not getting along with people later. But if you don't put that topic in there, you're going to be out of luck. Okay. That is all the information that I wanted to share. And I have left very little time for questions, but I'm happy to take questions if people have them. I think you could put them in the chat if I can see that, which I'm not sure that I can.
Let's see, we may need some technical help here to, let me see, panelists, there's a webinar chat. I'm not sure if.
There is a Q&A that I can open. If people have access to that, that might work. It may be that I have answered every question that people had, which is totally fine.
And if that's the case, we'll go ahead and keep it open. And if anybody does have a question, feel free to type it in and we can still get it to you. But in the meantime, I want to let everybody to know that next week on November 1st, we'll be back with the Citizens Law School again, and it will be one called Know Your Rights, Montana's Constitution, Bill of Rights. And our presenter will be the Honorable Anthony Johnstone, newly appointed to the U.S. Ninth Circuit Court of Appeals. And so any final words, Amy, before we close it up?
I don't think so, although that next week's, I think it will be a must-see sort of thing, because I think that's going to be really good.
And we have a thank you from our audience, and I would thank you as well. And on behalf of the State Bar Montana and the Law Related Education Committee, thanks everyone for participating and joining in, and we'll hopefully see you next week.
Thank you. Thanks for having me. Bye.
Bye-bye.